My name is Sarah Lawn. I am a Senior Associate in the Employment Group here in Arthur Cox. I'm joined today by my colleague Stephen Dardis, who is of Counsel in the Financial Regulation Group and focuses on insurance. As you're aware, the Individual Accountability Framework Act was signed into law in March of this year. Following that, the central bank launched a 3-month consultation period and recently published its feedback statement in relation to that consultation period, the final guidance and final regs. So today we are going to go through the key questions that our clients have been asking. So we're not going through chapter and verse of the Act and all the obligations that are going to come into force in the coming weeks and months, but just focus on the key questions from clients. Up to this point, we have been assisting our firms in preparing for their obligations. We've been reviewing policies, procedures to ensure they've been embedding the conduct standards, drafting notification letters, template employment contracts, template appointment letters. And certainly in the last few weeks, the focus has shifted to compliance with the upcoming 29th of December deadline, and in particular, certification. So what are your obligations in relation to certification, and what has changed since the 16th of November 23 and the publication of the updated documents?
I think one of the main changes on publication of the final guidance and regulations, Sarah, was the elimination of the 2-month grace period for the certification regime on firms. Firms now need to comply with the certification obligation in relation to all controlled function role holders from the 29th of December 2023. However, that is tempered by the fact that the Central Bank of Ireland have made it clear that they will take a practical approach to the logistical issues that this may pose for regulated firms.
Okay, great. There were changes in relation to non-executive directors. Can you explain those and the impact this will have?
Well, that was another one of the main changes coming out of the publication of the final guidance and regulations. The conduct standards will continue to apply to non-executive directors on and from the 29th of December 2023. However, the change is that non-executive directors have been excluded from the application of the senior executive accountability regime for 1 year. So that will only apply to them from the 1st of July 2025. The upside of this is that firms will have an opportunity to embed the senior executive accountability regime in relation to their executive directors and other senior managers for 1 year, and then go to apply the senior executive accountability regime to non-executive director roles.
So one other issue that caused a level of confusion recently with the publication of the feedback statement and the final regs and guidance, and I'll talk to this one, is the removal by the central bank from the draft certification regulations of an obligation on firms to report disciplinary action related to fitness and probity, and they gave the example of breach of conduct standards. So that's now gone from the regs. However, the central bank was clear in its reasoning for this and said that it expects in any event to have already received relevant detail in relation to such conduct under new or existing obligations. So we're aware that under the additional conduct standards, which will be imposed on your CF1s, your PCFs from the 29th of December 23, that they will have an obligation to report appropriately and promptly prescribed contraventions to the central bank. And your breach of conduct standards has been clearly stated to be a prescribed contravention. So bearing that in mind, as well as your sector-specific reporting obligations to the central bank that might also capture such conduct, new obligations may also be imposed on firms when the business standards come in. And also it is worth bearing in mind that there are existing obligations under the fitness and probity regime in terms of reporting disciplinary action to the central bank. So Stephen, what should firms be considering in terms of their D&O insurance in the context of IAF and SEAR?
Well, Sarah, this is a question that's coming up a lot with regulated firms at the moment. I think firms need to review their existing D&O insurance cover, particularly in respect of whether or not controlled function holders are fully covered by the policy at present, whether regulatory fines and penalties are covered as well, or whether they're specifically excluded, and also whether there is sufficient runoff cover now that the Central Bank of Ireland can investigate the fitness and probity of a controlled function holder up to 6 years after they have left that role.
Okay, very good. And finally, I'd mentioned earlier the business standards. When are these expected to apply to firms?
Well, that's still not clear at the moment, Sarah. The business standards are being separately considered by the Central Bank of Ireland as part of the review of the Consumer Protection Code, which is currently ongoing. The Central Bank is due to publish the consultation paper in relation to the review of the Consumer Protection Code in December 2023.
Thank you, Stephen, for going through these points with me today. As we said at the outset, I think the focus at the moment is very much on the 29th of December deadline, and hopefully then firms will use the momentum that has certainly gathered in the last few weeks and months, carry it through in the new year to prepare for the 1st of July 2024 deadline for the SEAR. So thank you also for listeners. And if you would like further information on IAF SEAR, you can go to our dedicated IAF SEAR section on our website, which contains briefings and videos. Thank you.